Okay. All right. So in the last class, guys, we introduced civil, and I want to take a few questions from our last class. Any person that had a question from the last class, please do let me know. Any person with a question? Any person with a question from the last class? None. None. All right. Sawa sawa. Again, somebody's putting up their hand. Yes. Proceed. Okay, they don't want to speak. They don't want to speak. So in the last class, we introduced civil, and guys have said civil litigation is not very complicated. Civil litigation is not very complicated. It is very simple. So there are just a few things you need to understand, how they're working, how they're operating, so that you are able to handle the question. Like we said in the last class, that civil litigation is all about moving from taking the instruction until the point where your client has been given a judgment that it or he or she. So until judgment is disposed, civil litigation is simply the movement of those documents in before the court. So you need to know which document is going to move where and which court we are going to be dealing with and how they're going to move. Now, civil litigation, like I've said before, is simply like a storybook. You guys read a lot of books. Now, when you read a book and you're trying to tell your friend what you read about, it is easy if you understand the story. So you can be able to tell your friend that I read this story about this and this. That is how civil litigation is. It is a procedure. Like I told you, that when you start from order 1, when you're talking to parties, talking about parties to a suit, is the same way when you talk about order 10 of question of non-appearance, is the same way we talk about the question of judicial review. So it's the same thing. So you need to understand and master your civil litigation procedure, not cramming. Don't cram, okay? Don't do the cramming. Cramming was done in high school or campus. Now you don't cram. If you cram, you can't cram your way out of KSL, that is. So you just need to understand and understand it as a layman, okay? The first thing you want to do is to understand it as a lay person. That is the first thing you need to understand. So if it is about parties to a suit, understand it as a lay person. If it is about judicial review, understand it as a lay person. It is going to be easy for you on the very first basis to know what you're dealing with. Are we together? Number 2, don't struggle. Don't struggle to cram case law. Don't struggle to cram sections of the law. Don't struggle to cram orders of the CPR. Don't cram just understand what an order is saying. For instance, what happens when a party fails to enter appearance? You don't have to cram order 10 word for word, but you need to understand what order 10 says. Okay, which is the consequence of non-appearance. If the question is talk about the question of judgment, how to prepare judgments, you don't have to go and cram order 21 and order 22. No, you just need to understand that under order 21 or under judgment, these are the things that go into judgment. So please, make sure you understand it from the layman's perspective. Make sure you understand it from the layman's perspective. It is very, very important for you. That is how you're going to understand it. So don't if you're new to this, don't struggle trying to cram the orders, order 1, order 2. No. Just understand the concept around it. Once you understand the concept around it, the examiner will not be asking you to name the orders. No, the examiner will be asking you to advise your client based on what you've learned. So if you've learned something about non-appearance, then you will be telling your client that according to the civil procedure rules, any person that fails, or if a defendant fails to enter appearance, the plaintiff may file an application for default judgment. So understand the concept. Now today, I want us to talk about first starting from overriding objective, and running through until we get to the point where we can start the commencement of civil litigation. The commencement of civil litigation. Are you together? So that is what we are going to be discussing. So you might have seen the overriding objective, and guys, you might have seen this aspect of overriding objective and inherent jurisdiction of courts. Now, when you look at Section 3A of the Civil Procedure Act, it talks about the inherent power of the court. At the same time, when you look at Section 1A and 1B of the Civil Procedure Act, it talks about the question of overriding objectives. Now, why do you need the overriding? What is the essence? What is the relevance of these questions of overriding objectives? What is that? What is that we're dealing with? Why do you need it, and where will you need it? Okay. Now, practically, first, before you understand the practical aspect of it, let's look at what this overriding objective is. Okay. Let us look at Section 1A, 1B of the Civil Procedure Act. Guys, are we together? So please don't use.
Yeah.
Yes. Use your full name, guys. Don't come to this class and use some anonymous names. I will not let you in. Okay? I will not let you in, and you'll say, oh, this guy. Oh, yes. Oh, just use your name, MJ. Who is now MJ? MJ died long time ago. There's only one of that person. So if your name is Mutinda, like someone called Mutinda in this class is using MJ, that is not your name, please. All right, so that is that. So let us go. I'm trying to project my screen so that you can look at Section 1A and 1B of the Civil Procedure Act, so that I explain the practical aspect of it, and then you can move very, very fast. All right, you will let me know when you see my screen. Let me know when you can see my screen. I'm projecting the Civil Procedure Act, Section 1A and then 1B. Somebody read for us if you can see it. I hope you can. If you can see it, please read it for us.
Yes, we can.
Okay, go ahead.
The overriding objective of this act and the rules made hereunder is to facilitate the just, expeditious, proportionate, and affordable resolution of the civil disputes governed by the act. The court shall, in the exercise of its powers under this act or the interpretation of any of its provisions, seek to give effect to the overriding objective specified in subsection 1. A party to the civil proceeding or an advocate for such a party is under a duty to assist the court to further the overriding objective of the act, and to that effect to participate in the process of the court and to comply with the directions and orders of the court.
1B.
For the duty of the court, for the purposes of furthering the overriding objective specified in Section 1A, the court shall handle all matters presented before it for the purpose of attaining the following aims: A, the just determination of the proceedings; B, the efficient disposal of the business of the court; C, the efficient use of the available judicial and administrative resources; D, the timely disposal of the proceedings and all other proceedings in the court at all cost affordable by the respective parties; and E, the use of suitable technology.
All right, thank you. Now that is the overriding objective. So it is the objective of the Act. Why do we have the Civil Procedure Act? Why is the Act laying down certain procedures? That is what we are asking. Okay, and that is what you're calling the overriding objective. Now, the main objective, the main purpose of the Act is really to facilitate just, expeditious, proportionate, and affordable resolution of civil dispute. To make it easy for every party to get a just and expeditious determination of the court. Okay? Now, these rules, if you read them together with the inherent jurisdiction, it simply says that the court at some point, in a layman's language, the court at some point can bend the rules to meet the ends of justice. The court sometimes can allow itself to bend the rules so that certain things can be achieved. For instance, like I've said, if you are supposed to file your plaint within 14 days and you don't, then the court, following the strict order of the rules, will dismiss that plaint. But if the court applies the overriding objective, the court can invoke the inherent power and make an order exempting you from filing that suit within 14 days. So simply, the court sometimes can be lenient on you, can be merciful on you, okay, can be sympathetic on you, so that you can file your matter, make your response, and then at the end of the day, meet the ends of justice. So in terms of doing that, the court must ensure that everything that is listed under 1B is achieved. So just determination of the proceedings, that is the first one. The second one is efficient disposal of the business of the court, use of judicial time and resources, the timely proceedings, timely disposal of the proceedings, and then use of technology if it is needed for purposes of ensuring that the dispute that is placed before the court goes quickly. So remember, the objective is to make sure that we are moving fast and we are applying justice. Okay, we don't want to waste time. We need to move efficiently. We have to make it just. We have to make it affordable. So efficiency, justice, expeditious, and also affordability. That is the purpose of the Act. The overriding objective of the Act is to ensure that every person that comes before the court gets justice. Number one, they get it quickly. They get it at a cost that they can afford. Okay, and then it is proportional. Are you together? Now, to ensure that happens, the court must always uphold justice. The court must always make sure that the proceedings are timely. The court must always maximize the use of the court resources, and the court sometimes might be required to use technology to ensure that the process is going on as indicated under section 1A1. Now, to further this process under the overriding objective, that is 1A and 1B, we have section 3A. Okay, now 3A talks about the inherent power of the court. Okay, nothing in this act shall limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice and to prevent the abuse of the court's process. Now, this inherent jurisdiction of the court is supposed to further the overriding objective. Okay, for us to ensure justice, for us to ensure, for instance, let me give an example. The overriding objective says, okay, that you need to ensure justice as you handle civil matters presented before you. Okay. Now, in a case whereby the defendant has failed to file the defense because they were sick. Now, ordinarily, you're not supposed to entertain that. Why? Because the rules provide that that person is late, and therefore you are not supposed to admit is plain. In fact, there's a summary judgment or a default judgment against them because they're late, but they were sick. Now, the civil procedure rules will not foresee the sickness. But when you come to the in the inherent jurisdiction, it says that the court is allowed to invoke its inherent jurisdiction to allow this person who was sick to file the defense out of time. So, in the other way, for us to ensure justice as per the overriding objective under 1A, we must invoke the inherent jurisdiction of the court. Okay, so Inherent jurisdiction of the court is really the sympathy of the court. Okay, the sympathy of the court. Now let us look at it practically. Now you have seen people drafting applications. So if you look at Order 51 of the Civil Procedure Rules, it provides that every application that you draft, you have to tell us. Okay, you have to tell us under what provision you're coming. Okay. For instance, if it is an application for injunction, the notice of motion you're bringing under injunction, you will write under Order 40 to support that. Okay. If it is an application, let's say for third-party proceedings, you bring it under Order 1. If it is an application maybe for execution of decrees, for instance, if it is garnishi, you'll bring it under Order 23. But there are certain instances where you are asking something from the court, but you don't have the reason. You don't have a legal backing. You don't have a specific rule or a specific order or a specific section that is allowing you to do that. For instance, you want to adjourn a matter. Okay, you want to call a witness. You want to do. You want some document to be removed. So in that instance, or you want an order to attach something. So it's either you don't have the rules or you've forgotten the rules. So how do you go about that? You are going to invoke the court's leniency. How do you invoke that? How do you invoke the sympathy of the court? That is under section 1A, 1B, and 3A of the Civil Procedure Rules. Now, anytime you're drafting an application, you have to tell us which rule you're coming under. All applications must be based on a specific rule. But if you cannot find a specific rule, more so in an exam where you are writing, okay, then it is okay for you to proceed and quote the overriding objective as read together with the inherent jurisdiction of the court. Are you together?
Yes, we are.
Yes. So anytime you're drafting an application, even in an exam, and you forget which rule you're coming under, please just make reference to the overriding objective and the inherent jurisdiction of the court. That is why you're going to say under section 1A, 1B, and 3A of the Civil Procedure Rules. Okay, so once you indicate that, you might want to add and all other enabling provisions and all other enabling provisions. Now that is supposed to alert the court that you are invoking their inherent jurisdiction. So it is nothing big in terms of even learning, but you just need to know why do you need it. Okay, why section 1A, 1B, and 3A? Because that is the only time you're going to invoke the court sympathy. Now, in all applications you're going to draft in the Civil Procedure Rules, or even in your exam, you have to provide the rules you're coming under. If you forget the rules you're going to come under, then you're going to give us section 1A, 1B, and 3A of the Civil Procedure Rules, except one application. There's only one application that you cannot make reference to the overriding objective, and that is an application that is brought under Order 45. Anytime you're making an application under Order 45, that is an application for review, you cannot quote section 1A, 1B, and 3A of the Civil Procedure Rules. And the reason is very simple. It is because at the point you're requesting the court to review, the court has become functus official, and therefore there is no inherent jurisdiction to review the matter. The court cannot review its own judgment just by invoking its inherent jurisdiction. It must be moved, and there must be circumstances and the grounds that must be met as per Order 45 Rule 1. So in that instance, you don't include or don't quote 1A, 1B, 3A. But in all other instances, if you forget, then you're going to mention 1A, 1B, and then 3A of the Civil Procedure Rules. Are we together?
Yeah.
Are we?
We are.
All right. So that is as much as I want to mention on the question of the overriding objective. You just need to know what it is at the back of your mind, and then how to apply it directly, even in the context of an exam. Okay, even in the context of an exam, then that is how you deal with it. All right. So if we are together, then yes, Jennifer.
I just want to be sure I'm clear. So, for instance, you're in an exam and maybe you're drafting an OS, and now you think maybe you have already named it an OS. So, to indicate, and you have forgotten under which order it's coming under. So you'll say 1A, 1B, 3A, and all enabling statutes. That's what you say. That's what you write.
That is what I've said all along.
Sorry?
That is what I've said all along.
Okay, I just wanted to be clear on that. Thank you.
Have you ever seen an application?
Yes.
What do they write under that application?
Perhaps it will be order 40, rule 1, and all something like that. Something to that effect. Yeah.
Yes. Yeah. So
okay, thank you.
You have to write it. Now, remember, we will talk about drafting applications. And one of the key elements when somebody is marking your application, one of the things they're going to look at is whether you have the rules you're coming under. Okay, so if you don't indicate the rules you're coming under, then you might miss a mark. So to avoid missing that mark, just make sure once you write notice of motion, chini yake, just under it, write under order this, or under section this, or under article this. But if you don't know any of that, you're going to provide section 1A, 1B, and the 3A of the Civil Procedure Act and all other enabling provisions. Yeah. All right, Kevin.
So is it section 3A of the Civil Procedure Act, or it's 3A of Appellate Jurisdiction Act? Which one?
What do you mean? What do you mean appellate jurisdiction? It is section. We've just read a section right now, which is section 1A, 1B, talks about overriding objective. Section 3A talks about inherent jurisdiction. We've read all of that. And that is the Civil Procedure Act, not rules. Okay, Civil Procedure Act.
Thank you for that clarification.
All right. All right, Sawa. So guys, I want us to move now to the first thing. Unless somebody has a question, I want us to go to the first thing, which is a question to do with parties to a suit. Okay. Now, if you look at your course outline, topic 5 is parties to a suit. Now, remember in the last class, we discussed some of the things you will consider, some of the considerations before you draft, considerations before you go to court, what you consider before you go to court. Okay, one of the things we said you consider is jurisdiction, which we already discussed, the question of jurisdiction. The next thing we said you consider is the question to do with the parties to a suit. Now, why is this important? Parties to a suit is very important. Why? Because at all times, okay, at all times, you can't sue the wrong person. You need to know who you're suing. Guys, if you get a question and you're being told, proceed and draft, don't just start drafting. Go back to the question and ask yourself, who are the parties in this question? Okay, who are the parties in this question? Are you together? Who is suing who? That is the first thing you need to ask. Because you can't start drafting. Jurisdiction is not even important if you don't know who the parties are. Okay, so you first start with the parties, know who the parties are. And then you proceed and draft your application or draft your pleading. Are you guys together? So it is very important. So please, 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 please make sure that you understand that. Make sure that you understand that. So parties to a suit. So under parties to a suit, there are a few things that I want us to understand. This is a very complicated one, but I want you to walk with me very slowly and slowly because it is important for you to understand it. Now, most of these things you're going to learn in civil, they will not be said directly. The examiner will not say, hey, my friend, or my dear. Like I said before, examiner, you can never be a dear to the examiner. That will not happen. Okay, so the examiner will not call you my dear. That cannot happen. Neither can the examiner say, hey, here is a notice board of what we are going to discuss or to set. That will not happen. The only thing that will happen, they will just tell you that someone random was walking somewhere random, doing random things and being random with themselves, and then something random happened. So you need to advise this random person on the things that he was doing or what you need to do. So most of the things you are going to learn today, or even not entirely, even in the 9 units, they're just applications. You have to apply that knowledge somewhere. Okay? Because questions should be set differently all the time. You just need to apply yourself. Now, I want you to understand the context of parties to a suit. So the first thing we're going to discuss in parties to a suit is how do we frame the parties? First, what is the category of the different parties, the special categories of parties in a suit? Number one. Number two, how do we frame them? How do we frame these parties? Okay, how do we frame them? Once we know how to frame them, then we are going to discuss the different classes of, who can sue, the representation, talk about representative suits, the class action suits, and the test suits. Okay, and then we shall discuss the question of joinder. Fine. You have started your suit. Can you join someone? Joinder. Joinder is the act of someone coming in and someone going out. That is joinder. Are we together? And then we shall discuss the question of the third-party proceedings that is coming directly from the question of joinder. Once we discuss that, we shall see how to prepare the two, that is an application and also the third-party notice. And then after that, we will proceed and defer the interpleader applications to the other topic, which is topic 7, which is interlocutory applications. Okay, so I hope that we are together. So first understand who are the parties. So that is where we are starting from. Now we have different categories of people that are called the special class in terms of parties. The first person is a minor. Okay, a minor. How do we treat minors in the suit? Going the same way as a minor is a person of unsound mind. Any person that is of unsound mind. Okay, don't say the person is mad. Okay, if you are writing an exam, don't say that James is mad. Okay, the examiner will be extremely mad at you also. Are you together? So when you say James is mad, the examiner will be equally mad. So don't say mad. So mad is not a legal term. Just say the person is of unsound mind. Okay. So the third person that we also deem very special is the deceased person. Okay. How do you handle deceased people? Somebody that has died or somebody that died. How do they sue and how do they get sued? Very, very important. Companies. Okay. How do you sue companies? Sole proprietorships, partnerships, aliens. How do we sue aliens? Okay. So those are the various categories of people that we have the last one is the government. How do we handle suits against the government? Okay. Now, have that at the back of your mind. And this information is going to inform everything you're going to learn up to the question of judicial review, the very last order, order 53. So please stick with me. So the first person is a minor. So minors are people that are below the age of 18. Now these people can't sue in their own name, neither can they be sued in their own name because they are below the age of 18. So assuming that James Minor, okay, James Minor is the minor boy. How is this minor supposed to sue? How do they bring a suit? Okay, now anytime a minor is suing, that minor must sue through a next friend. Okay, if you're a minor, you're going to sue as the next friend. So the next friend will sue on behalf of the minor. Okay, the next friend will sue on behalf of the minor. Are you together? How is the minor sued? Okay, the minor is sued through a guardian ad litem. A guardian ad litem. So suing through next friend, defending through the guardian ad litem. So let's say James Minor. So again, remember that a minor, you don't mention the name. So if their name is James Minor, don't say James Minor. Okay, you have to make sure that you use the initials. So the initial could be anything. So if they're James Minor, then that is JM. You just use the initial of the name, but make sure you don't use the name. So let's get an example quickly. So assuming that Susan is the mother to James Minor. So you're going to have Susan, okay, suing as the next friend to who? James Minor, which is JM, into bracket, minor, and then plaintiff. That is how you address that. Now, remember, children, they sue through the next friend. So Susan, who is the next friend of the guardian, will be suing on behalf of the minor. So Susan suing as the next friend to the minor. So again, the initials of the name of the minor into bracket, say minor, and then the dash, and then the plaintiff. The same applies for a person of unsound mind. If you're a person of unsound mind, I could have shown you the screen. I could have projected my screen so that we do it together. But these are things that I don't need to show my screen because we'll spend so much time doing it and then we'll not cover a lot of things. So again, this is something that I know everybody knows. So when you are suing a minor and a person of unsound mind, then you have to sue through an ex-friend. The same way, if James Minor is a person that is of unsound mind, then again, if Susan is the guardian, then it will be Susan suing as the next friend. Again, remember that persons of unsound mind, you don't write their full name. Okay? You don't write their full name. So always make sure that you protect their identity because it's a requirement under the law. Are you together? So that is how. So persons of unsound mind, you sue through an ex-friend, the same way as a minor. The next thing is, how do they get sued? So if they are being sued, how do they defend that suit? At the same time, they defend through a guardian ad litem. Okay, so you can either have Susan sued as a guardian ad litem to JM into bracket minor, or defending as a guardian ad litem to JM minor. So it's simple. Suing us, sued us. As simple as that. That is for both minor and minors and persons of unsound mind. Now let's go to the next person, who is the deceased person. So the deceased person, the principle is very simple. The principle is you cannot handle the estate of the deceased person if you don't have a grant. So you first get a grant. So when you get a grant, that grant makes you a personal representative. The grant will make you a personal representative. Are you together? The grant will make you a personal representative of the estate of the deceased person. Okay. Now, let's say James Minor is our deceased person, and Susan is the personal representative. So you're going to say, Susan suing us, a personal representative, to the estate of James Maina, into bracket, deceased dash plaintiff. Suing us, a personal representative. How will they defend? Again, they're sued as personal representatives. So Susan sued us. So suing us, sued us, the personal representative to the estate of the deceased person. Now remember, anytime before you sue on behalf of an estate of a dead person, you have to take a grant. You first have to take a grant at litem, and then you can institute a suit on behalf of the estate of the deceased person, unless you have the full grant. So nobody can just wake up and then start a suit on behalf of the estate of the deceased person. Even if you are the wife of the deceased person or the spouse, or you are the mother, you first have to apply for the limited grant ad litem, and then you can institute the application or the suit as a personal representative to that estate. Tuko sawa? Are we together? Okay, fine. Let's go to companies. The rule of company is very. Is she breaking, or am I the one breaking? Okay. Confirm. I think she's the one breaking, or is it me?
She's the one breaking.
Thank you. Now, the rule of companies is very simple. All companies can be sued and can sue and be sued in their own name. So if Safaricom, just Safaricom plaintiff, Safaricom defendant. Very simple. Now let us go to sole proprietorships. Now, a sole proprietorship is a business name, for instance, legally. So if this person is called Mama Mboga, the business name of this person is Mama Mboga. Susan is a Mama Mboga, or Susan is a small business owner, and she's suing as a business entity. Then you want to indicate that they're trading us. Sole proprietorship is a business, and therefore you have to tell us they're trading us. So you're going to have Susan TA, T stroke A. T stroke A means trading us. T stroke A, trading us. Mama Mboga, maybe traders or limited. No, not limited. Mama Mboga enterprise dash plaintiff. Susan trading us. So you have to tell us trading us, because they're trading as a name. So either that name is a registered name, or is just a general sole proprietorship that is formed without any formalization. So trading us, TA, trading us means you are trading in that name. Okay, so that is for sole proprietorships. Now let's go to partnerships. Now for partnerships, if it is a limited partnership or an LLP, if it's a limited partnership or an LLP, they can sue in their own name. So if the LLP will sue in its own name, again, the limited partnership will sue in its own name. However, if it is a general partnership is not registered, it's just a business that was formed generally, then you are going to have at least two partners. You will have at least the name of two partners. So first, let us establish the name of the partnership, the general partnership. Let's assume it is Mama Mboga Enterprise. So Mama Mboga Enterprise is the name of the partnership. Okay. So if the Mama Mboga Enterprise is the name of the partnership and it is a limited partnership, you sue Mama Mboga Enterprise, or Mama Mboga Enterprise will sue in that name. Okay. If Mama Mboga Enterprise is an LLP, you sue and be sued in that name. But assuming that Mama Mboga Enterprise is a general partnership, then how do you handle that? You have to mention at least two partners as you sue, or as they get sued. So assuming Susan comma, Penina, okay, trading as again, Mama Mboga Enterprise, the plaintiff or the defendant. So if it's a general partnership, you have to indicate trading as the same way if it is a sole proprietorship. Are we together? So at least two partners. So that is how you sue partnerships. That is how you sue partnerships and general and general sole proprietorships. The next one is aliens. The rule of aliens is very simple. Who is an alien? An alien is a foreigner. Okay, an alien is a foreigner. How do you sue foreigners in Kenya? Now, it depends. If the foreigner is an alien friend or an alien enemy. An alien friend is a person that is coming from a country that is not at war with Kenya. For instance, if you're coming from the US or South Africa or Rwanda. Uganda is always at war with Kenya, but not officially though. Uganda, okay? So if you're a foreign citizen, though Ugandans are not considered foreigners. You know, there's some people in Busia border to up. When they cross to the other side, they think they're abroad. Mtu wako Busia border hapo. So if you're coming from that side, you're not abroad. Okay. Uganda cannot be abroad. So watu wa Namanga is not abroad, please. If you cross just 2 kilometers from the border, you're not abroad. So if you're coming from if you're South African, you're an alien friend. Nigerian, West African, Tunisian, okay? You're coming from those countries, then you're an alien friend, so long as your country is not at war with Kenya. If you're coming from Somalia, it's again a very tricky kind of relationship, a very tricky one. So it depends. Not all the times Somalia is fighting with Kenya. I think it's a long time since they fought. They're still waiting for the ICJ to render the final findings, but Kenya and Somalia are still cool. Okay, so it depends. If the country has declared war, for instance, Israel has launched war on Palestine, so that is an active war. So until that war is declared officially by Kenya, then that country is not at war with Kenya. So if you're coming from a country that Kenya has declared war on, then you're an alien enemy. An alien enemy has no right in Kenya. They cannot sue anyone. Okay, they cannot claim any right. Okay, but they can be sued. So if you're an alien friend, you can sue and be sued in your name and in the name of your passport. So of course you use their passport and their name. They get sued both in the civil courts and the criminal courts. If you're an alien enemy, you can't sue in the civil courts. Neither can you sue in the criminal courts. Why? Because you as an alien enemy getting legal redress in Kenya, it will look like now the Kenyan courts are trying to help your country. Okay, so if you declare war on Ethiopia, for instance, you declare war on all Ethiopians. That is how it works. So you cannot declare war on Ethiopians and then you still are causing with the Ethiopian citizens. So if war is declared, even the Kenyan institutions cannot help you as an alien enemy. Are we together? So that is but alien enemies can be sued. They can be sued, but they can't sue. So that is also important for you to understand. How do you sue the government? Of course, when you sue the government, you can sue the government. Every governmental department is a corporate entity that is established within the law and within the statute. They can be sued in their own name, but of course, always make sure that the office of the Attorney General is added as a defendant or as a respondent. So the AG must always be there because the AG is the chief legal advisor to the government. Though theoretically, it is what it is. So you have to have the AG as a party to that suit. So that is how far we can go when it comes to the different categories of parties that we have in civil. So any question up there? Any question up there? No question. All right. So that is the question to do with a framing of parties. The next thing is the question of who can sue. Now this is literal. Who can sue? Any person that has a claim, so long as you have a legal claim that is still moot. Yes, Robert.
This is in regards to the county governments. They have their companies, like the water companies that they run. Supposing you have a dispute with their water company, say, for instance, Busia Water and Sewerage Company, must the Attorney General also be party to that suit?
No. Now we have two levels of government. We have two levels of government. Okay, we have the county government and the national government. Now the national government is the AG. The county government is the county attorney. Okay, so the county attorney does everything that an AG will be doing to the national government. So if Busia county government has a water company registered or created specifically for them and given jurisdiction within Busia County, then you sue the county government of Busia. Okay, sue the county government of Busia, and the person that is going to be a de facto defendant there is the county attorney. Okay, because they have they have the same mandate as given to the AG. So it depends. It depends on whether it's a national government or a county government. But also we have now the water companies for the national governments. The water it's the questions about being devolved, but the angles to it. All right, Noor, Yusuf.
To a minor on whose behalf a suit had been filed by a next friend. And during the pendency of the suit, they attain the age of majority. What happens?
You apply for substitution. Just a normal chamber summary or notice of motion. You substitute yourself as the plaintiff or the defendant, depending on whether you are the plaintiff or the defendant. So it's a normal application filed under Order 32, and you apply for substitution that you are now full of age and you want to be named as the full plaintiff and take charge of the the proceedings.
Thank you, counsel. Further to that, can they elect to abandon the suit?
Why are you abandoning the suit?
No, that is to the minor, maybe for reasons best known to them.
Yeah, if you are the plaintiff, yes. Remember, the suit is yours. We are going to talk about the question of dominus litis, which means the plaintiff is the master of the suit. You, as the plaintiff, you are the master of the suit. So if you're the master of the suit, you can abandon your suit at any time. That is your personal decision, of course. You can decide to stop. So if you're suing me right now, and you decide to stop, I come to your house and we talk nicely, you will stop suing me. It is you to decide, but it's not a legal requirement that you have to abandon the suit. Abandoning a suit simply means you make your own personal decisions to abandon a suit. Okay.
Thank you.
Oh, hey, okay. Poor John.
Okay. What if in an instant whereby the minor chooses the party as if they were in the suit to continue, would the court allow that?
The court is not supposed to allow that, but the courts do allow that. The courts do allow. The court can decide to have, because remember, you have to move the court. The court can decide. The court can decide to proceed, because remember, the court is not monitoring your age. Unless the court is moved and the court will now have to make a decision, the court will not care whether you've turned 30 or 100. The court will continue with the suit until one of you brings an application. Okay, until one of you brings an application that, hey, the plaintiff is now full of age, they want to substitute themselves, or even the defendant can force you to substitute by filing an application for substitution or asking the court to ask you to substitute. So again, the court will not keep tab of the age of the person, but is upon the parties to proceed. So sometimes, unless the court deems it fit, because it is a case-to-case basis, unless the court deems it fit that now, because you're an adult, let us now substitute you for the interest in, within that case. Normally, the court doesn't care. Together?
Yeah,
Alingo,
thank you.
Alina? Okay.
Yes, Mwalimu, can you hear me?
Yes.
Okay, my question is, when a suit is when a minor brings a suit in court, the person is the next of friend. For example, if it is not apparent that this guardian, is there any need to produce evidence to show the relationship that exists between the minor and the guardian?
No.
If it is not apparent.
Unless it is contested, there's no need, there's no requirement that you have to show that you're the mother, unless the defendant is objecting. Or the defendant can raise an objection that you are not the next friend, because remember, the next friend there's a reason why the law calls it the next friend. Either way, you must be a friend in either legally or morally. So either you're the parent, you're the brother, you're the sister, you're related somehow, or you're the legal guardian, then you become a next friend. Okay, but if you're not that related, then
Yes.
you can do it, yes, but sometimes the defendant can object that you are not even related to the minor. Why are you suing? And then you can now start explaining to the court how you, a foreigner, started getting related to the minor. Okay, so normally, unless it is specifically objected by the defendant, you don't need to.
Okay, one more question, Mwalimu. Now, I saw somewhere in an application, it was basically a plaint. And then among those documents that were there, I saw the one written an authority to sue. Where is it necessary, and what is the purpose of that authority to sue? Is it the minor giving it, or is it the minor giving it, or is it now the guardian who is giving now the authority to the advocate to proceed on his or her behalf?
So in the instance where you're suing, this one is specifically for advocates. An advocate that is suing on behalf of a minor must get the authority to sue from the guardian of the minor.
Oh, okay. Okay.
So there are instances where an advocate can sue. Okay? An advocate can sue on behalf of a minor. Okay? So if an advocate is suing on behalf of a minor, this advocate must get the authority to proceed or the authority to sue from the guardian of the minor.
So
but
the
that
party
doesn't come again.
Okay, so the party up there will be like
The advocate.
Yes, so it will be the name of the advocate, Jackton.
Yes.
Jackton suing on behalf as an next of friend to this Jane Wairimu minor.
On behalf of JW minor.
Plaintiff. Okay. Okay.
So
thank you.
that is all required. Advocates are allowed to bring suits on behalf of minors in certain matters. Of course, it depends from from circumstance to circumstance, but they can only do that with an authority to proceed. That is from the guardian of the Sometimes they get that authority from the court. Sometimes if the guardians are not even there, then they can get authority to proceed from the court. Because remember, you cannot just become a next friend. It must be there. If it is, you can't force that friendship. So it must be legally established. So either you're the guardian, the relative, and then if an advocate, you must get that authority from either the guardian or the court, and you have to file it as part of your documents. I hope that is clear.
Yes, that is clear. Thank you, Mwalimu.
All right, so let's go to the question of who can sue. Of course, I've said anybody can sue so long as they have a claim, so long as they have a suit, so long as they have a point or something wrong has been done to them. So anybody can sue. So long as you are having a cause of action, you can sue. That is the simplest answer. Sometimes the exception to that rule is you can have a suit on behalf of others. You can have a suit on behalf of others. And this is what we're calling representative suit. Representative suits. Now, a representative suit is a suit whereby someone brings a suit on behalf of other people. Okay, so the first obvious one that you know is a class action suit. This is whereby a class of people, someone is suing on behalf of a class of people. So if, for instance, the students of Kenya School of Law are suing the Kenya School of Law, then one person can bring this suit on behalf of all the students at Kenya School of Law. If nurses are going to be suing the government, then one nurse can sue on behalf of this. Okay, so it is a representative suit. It is a representative suit. And sometimes also we have the public interest litigations whereby Okia Mtata is suing on behalf of everyone. So that is a public interest litigation, which is a representative suit. So anytime someone is suing on behalf of another person, that becomes a representative suit. Okay. The other one is what you're calling the test suit. So a test suit is obvious. You know what a test suit is under 36. A test suit is where. Okay, I hope you can hear me. A test suit is simply whereby there are several suits. There are several suits against the defendant, against one defendant by a lot of plaintiffs. Okay, so we have one defendant being sued differently by 10 plaintiffs. Okay, by 10 plaintiffs. Now, in a civil suit, there are normally two things. The first thing is liability. Okay, the next thing is now damages, what they normally call quantum. Okay, so every suit that you bring in a civil court, there are two issues to be determined. The first thing is this person liable? For instance, if you sue me for defamation, the first question the court is going to ask is, am I liable for that defamation? Was what I said defamatory? And then the next question is, how much am I supposed to pay you as damages for defamation? If you sue me for breach of contract, the first question is liability. Am I liable for breach of contract? The next thing is quantum. How much am I supposed to pay you? If you sue me for a tort, okay? If you sue me for a tort, the first thing is, am I liable for that tort or negligence? And then the next thing is how much. So based on that, one thing is common across board. So if 10 people are suing the defendant for the same thing, okay, 10 people were in the same car that caused an accident and they're suing the driver. So there are 10, they're suing the driver for negligence. So the first thing the court must answer in all the 10 suits is the question of, is the driver liable? The question of liability. Now, this is a factor that is constant in all the files. And then after that, we have the second question is, how much should be given to each and everyone? Now, because of that, we don't have to go to first file, determine liability, second file, determine liability, third file, determine liability. No, we don't have to do that. What we need to do is, let us pick one file. That one file will be used as the lead file, okay, to establish what we are calling liability. That lead file is what will be establishing liability. Because if you guys are in the same vehicle, if the court finds that this person is liable according to the file number 1, then it means he is liable in all other files as well. And therefore, the finding on liability on one file will be replicated down across all the 10 files. And then each and every party will now come and avail evidence in terms of how much they suffered, and then they will be paid. Because remember, suffering now is different. Payment will be different based on the injuries. So I broke my leg is different from somebody that broke their back. I broke my arm, different from somebody that died. So damages will be assessed based on the evidence that is pleaded. So that is a test suit. So when you pick one file to establish liability, and then that liability finding is replicated in all the files, and then after that, the court will invite all the remaining files to present evidence for payment of damages. That is a test suit. Now, after that, let us discuss a very important thing called joinder of parties. Joinder of parties. What is joinder of parties? What is joinder of parties? Very simple. Joinder of parties, as the Bible says, should be somewhere around Luke 7. Okay. The Bible says, I hate divorce. The Lord himself says, I hate divorce. Okay. Those that are ready, every time they're leaving their partners, where do you want your partner to go to? Ladies, if you look at the statistics, men are few. We already few. So if you leave your partner, where do you want him to go to?
To another one.
No. The Lord himself hates divorce. Okay. So even the Bible says that a man shall leave his place in Thika Road and come to your place on Mombasa Road, and you guys shall become one. Okay. So be one. Be one. Ukichoka kunywa maji na uendelee na mapenzi. Okay. Sawa. So when you talk about joinder of parties, it's a simple term. And I want you guys, before I go further, from where we started on parties to a suit, I want you to understand as a lay person. Don't understand it as an advocate. It's going to confuse you. First, understand it as a lay person. Who are the parties to a suit? This and that and that and that and that. Okay? Who can sue? Of course, any person that has a claim. Okay? Now, in terms of joinder of parties, it is very important for you to understand what is a joinder. Joinder simply means to join to join. Okay, to join, to bring a person that wasn't there. That is a joinder. So joinder of parties in a suit simply means you are bringing a party in a suit. So in terms of joinders, we are going to discuss our key main aspect. The first one is who can join a party in a suit. The next one is the joinder of interested parties. The third one is what we are going to call non-joinder and misjoinder. And then lastly, we shall talk about third-party proceedings. Very simple. Joinder. Who can join and when can you join? So let's start with who can join. Okay? Who can join? Or before we get to the question of who can join, let us talk about when can you join? When can someone be joined in a suit? Okay? When can somebody be joined in a suit? That is very, very important. Okay? Very, very important. When can somebody be joined in a suit? Okay? Now, the answer is very simple. A person can be joined in a suit if there are common questions of law or common questions of fact. So let's assume myself and Michael Waweru. Okay, myself and Michael Waweru. Okay, guys, some people are crazy. Guys, when you pay for class, I'm not an angel. Okay, I'm not an angel. I will not fly into your phone and then see your phone and say, oh, this one has paid. Plus, I can't go, I will not know. So someone just kept quiet, sent me no message, just kept quiet. How am I? Yes, sometimes guys are being funny. How can I know? I won't know. So just when you pay, just send me the message and the name. Is that too much to ask? Some people are just crazy. Your ancestors are chasing you. Now tell your ancestors to stay away from me. I don't know that. Okay. Name is Takeshida. Sawa. So let's talk about what I was mentioning. I was saying Michael Waweru, and myself. We have a suit. So what will inform Michael Waweru to join me in his suit? Or what will inform me to join Michael Waweru in my suit? That is the question of when can you join? Okay? So if you have two suits that have a common question of law or a common question of fact, then that or those two suits are supposed to be joined together. Okay, you know something called consolidation and everything else. So it must be a common question of fact or a common question of law. How does that happen? Okay, so you will get a question in an exam. Okay, you will get a question in an exam. Are you together? And you're being told that Michael Waweru has this case, Jackton has this case, and this case is supposed to proceed to pre-trial conference. Okay, this suit is supposed to proceed to a pre-trial conference. You are the judge of the magistrate. What orders will you make? So the moment you see there are two cases and you know the overriding objective that we need to ensure a fast and expeditious, okay? A fast and expeditious process. You know very well the first thing you're going to do is to order for the joinder of both matters. If you see 10 similar suits suing the same person, what should come to your mind is a test suit. So guys, have the knowledge at the back of your mind, understand it as a lay person, and apply it as a lawyer, and put some legal work. There's nothing crazy in terms of these things. Just think as a lay person and then put some legal terms in it. You will be fine. Okay? Are you together? All right. Now, there must be a common question of fact or a common question of law. If it is negligence, both of them need to be talking about negligence. Now, it is not negligence that one negligence in Mombasa and one in Nairobi. No, it is common question of law and a common question of fact. Both of them were in the same car that accident happened. Okay, so it must be in criminal we call it common or similar transaction. So here we are calling it a common question of fact or a common question of law. That is when you join. So if I am suing Abdullahi and Michael Waweru is also suing Abdullahi, we have the same common question of law or a common question of fact. We shall join. Okay? So that is what you need to understand. That is when you can join. When can somebody be joined? They can be joined if there is a common question of law or a common question of fact arising from the facts provided. Are you together? So, who can join? Number one is the dominus litis. That is the plaintiff. The plaintiff can join any person in a suit at any time. The plaintiff can join another plaintiff. You can bring a co-plaintiff. Okay? And then the plaintiff can bring another defendant. So the plaintiff can bring anyone they want at any time. That is joinder of parties by the plaintiff. The next person that can join automatically is the court. The court can bring a co-plaintiff, the court can bring a co-defendant. So those are the two people that can join automatically. Okay, they can join automatically, but the most important one is the dominance litis, that is the court. The court can join any person at any time, and then the plaintiff can join any person at any time. Okay, now the defendant. The defendant cannot join anyone at any time. In fact, the defendant cannot join anyone in a suit. Okay, the defendant cannot join anyone in a suit. Why? Even logically, thinking as a lay person, you are the person who has been sued. You can't tell me who to sue. You can't tell the plaintiff who to sue. So you can't join a defendant. You can't bring a co-defendant. At the same time, you can't tell me who to sue with. If I sue you, you can't ask me why I'm suing you alone or why I'm not having my co-plaintiff. That is my business. Okay, mine and yours. Okay, and the yours is third-party proceedings. Are you together? So the business of the plaintiff is to join parties to decide who to sue and who to sue with. That is who the plaintiff is and the co-plaintiff, and who the defendant is and the co-defendant is, or the first and second defendant are. So that is the business of the plaintiff. Now, what happens if the defendant feels like there is someone that they want to bring into the suit, someone that they think that should be sued also? What happens in that instance? The defendant has only one remedy, and that remedy is under 1 rule 15, which is the question to do with joinder of, or the question of instituting third-party proceeding. So you need to bring a third-party proceeding against the person that you think is also liable. So when you bring in a third party, the third party is not part of your suit. In fact, it is a suit within a suit. The suit between you and the plaintiff will continue normally and progressively like that without being interrupted. The suit between you and the third party will also continue just like that. Are you together? So that is what you need to understand. So the plaintiff is the dominance litis, can join any party at any time. Number 2, the court can join any party at any time. Number 3, we have the defendant. Unfortunately, this person cannot join anyone at will. Okay? Therefore, if the defendant feels like they want to join anyone, they will need to institute a third-party proceedings against the third party, which is a suit within the original suit. Are you together? So that is third-party proceeding. So the court, the plaintiff, and the defendant can only bring a third-party proceeding. Okay, we will come back to that. Now let us talk about the question of non-joinders and misjoinder. So non-joinder is when you are supposed to have someone in the suit as the plaintiff or as the defendant, and you didn't bring them in. You failed to sue someone who you are supposed to sue, or you failed to have someone as a plaintiff who was supposed to be the plaintiff. So that is non-joinder. Okay? Number 2 is misjoinder. Misjoinder is when you have the wrong person. When you have the wrong person in the suit, okay? You are supposed to sue Diana, but you have someone else who is not Diana. So therefore, that is a misjoinder. You joined them mistakenly, okay? The only question around that you are going to find a lot of time, even in 2022 question 6, you will be told that somebody sued party X. However, they were supposed to sue party Y. How do they go about that? Your brain is supposed to tell you that, hey, this is joinder of parties. This is a misjoinder. Okay? This is a misjoinder. I've sued the wrong person. So remember, misjoinder and non-joinders can also happen at the same time. You can have someone you fail to bring, At the same time, you have someone you brought mistakenly. So that is joinder and that is misjoinder and non-joinder. The other question is, how do you correct that? How do you move from a point of non-joinder or misjoinder? It is very simple under order 8, which is you amend the suit to join the party that you did not join, or to remove the name of the person that you misjoined. That is how you correct joinders and non-joinders and misjoinders. Amending the suit to add and to remove. Okay, that is very simple. So when we get to order 8, we shall talk about amendment, applications to amend under order 8 of the civil procedure rules. And it's a very simple thing. You're just adding someone and removing someone. And drafting applications, when you're drafting an application, is the easiest thing. Drafting an application, somebody is now wondering, how is that application supposed to look like? Because you want to cram. Okay. Every time you go to church, for those who are Christians and those who are Muslims pray like every day. Is it 3 times or 5 times? Abdullah Siyad, how many times do you pray? Abdul Kadir, Dami. 5 times. That is serious prayers. 5 times. So every time you go to the mosque and every time you go to church, tell God to remove from you the demon of cramming. The demon of cramming. You can't cram your way to Kaisar or out of it. You can't. So your main prayer item is not to get 9 P's. Just tell God to make you understand and not to cram. You've seen people that have a legacy of cramming. Yeah? They cram until that morning, they don't speak. They just seeing smoke coming from their ears. If you touch them a little, they've forgotten everything. Don't cram. Don't be like that. You will die, literally. Okay, don't cram. Just make sure you understand it from a layman's. If it is joinder, hakuna kitu ya kukram hapo. We have not even mentioned any order, but you just don't cram. Just make sure it is okay, joinder. This is bringing 2 people in the same suit, removing and adding. Okay, how do we correct joinder? Amending. How do we amend? Oh, this is order A. It's simple, guys. So don't kill yourself. Don't kill yourself. Okay? And please, pray a lot of times. Pray a lot of times. Christians only go to church once a week. Once a week. And they're making the loudest of noise. Hata hiyo Sunday waendi, wanafua. Na wana watch movie. Ini moto inawangoja huko binguni. Moto ingine kali sana. Haya. Endelea kufua. So that is a question of joinders and misjoinders. So the most important thing about this one is not even to know it, is to know what circumstance brings a joinder. The worst thing that happens to people all the time is not because they don't know. If the examiner was to tell you what is joinder and misjoinder, you will of course get it all 100%. But I've told you, the examiner is not your friend. Okay? That person is paid specifically to make sure that you failed. So they will not tell you that. They will tell you that James was knocked down by a car. James is now very mad and he wants to sue, and he has sued this person. So from there, you need to know, why has James sued this person? You know there's a problem here. And how do you sort it? So most of the time, you'll only realize, when you're getting an exam room, 2 things happen to you. You will panic. The moment you panic, your brain will remain outside. Okay, your brain remains outside. So you'll get done, sit exams, and then by the time you board that bus, you know that ugly bus that goes through Karen, that green Naboka, looking like a loaf of damaged bread, that bus, that is when your brain will start joining you back. Yeah? When you sit in that bus and you're now navigating through Gataka or Galeria, going to town. That is when your brain starts creeping in and you remember that that question was not injunction, it was amendment. And then you start crying. So the best thing to avoid that is relax and then understand it as a lay person and ask yourself, read it again and again and again, and be calm. Okay? Be calm. You will be fine. You will be fine. And like I told you, you have a lot of time. You guys have a lot of time. November is ages and ages away. Okay? So it is okay for you not to know now, and it's okay for you to start learning. So don't kill yourself. Again, some of you are about to start being religious and relocate to the mountains and the forest to start fasting and praying. Don't do that. All right, so that is the question of joinders and misjoinder. We are done with that. Now let us talk about the joinder of interested parties and the amishes. Okay, the one you call an amicus curiae. So a very easy concept. We are not going to mention it a lot of times. I'm just going to mention that interested parties are parties that are interested in the outcome. Interested parties are interested in the outcome. They are biased. So if it is petitioner versus respondent, an interested party will be supporting one side. Okay? An amicus is a friend of the court, is neutral. Okay, so how do you enjoin interested in the amicus parties? So the first thing, they have to make an application. Normally chamber summon, but you can do it in a notice of motion. Like the trend is you can always get the orders whether you draft either of them. So long as you draft an application, you get. So you make an application and have your supporting affidavit, and you have to indicate what you want to be. So the main order you're praying for is, please join me as an interested party. And then your affidavit will indicate why do you want to be joined as an interested party. And then you go to the amicus. At the same time, make an application, you pray to be joined as an amicus. At the same time, you prepare your affidavit, and your affidavit will indicate why you want to be joined as an amicus. Okay, so an interested party, I will give you an example with FIDA, who is the notorious interested party in almost a lot of suits. So anytime there's a suit challenging the right of children and the right of women, you will always see FIDA Kenya being an interested party. Okay, because FIDA, through their policies and the national mandate, they have certain, there's an outcome that FIDA is looking for, and this is an outcome that supports the right of women and the right of children. Okay, so if you're in court and you see the opposing counsel is saying, Your Honor, I'm appearing on behalf of FIDA. Hey, just whisper to your client that, my friend, committee direct, huku ni kunoma. So always, at all times, you need to understand that interested parties are interested. Why are we calling them interested? They are interested in the outcome. Okay, so how do you become an interested party? Not just by saying I want to, by making an application to be enjoined, and you have to show what is your interest. My interest is, I am FIDA Kenya. I am mandated nationally to engage and understand and deal with questions to do with the right of women and the right of children. Okay, so that is as simple as that. So when you're FIDA, you do that. If you are the AG, you've seen the AG, but most of the time the AG will apply to be an amicus. So if it is a question of national importance, they will become an amicus to guide the court. Though the last serious AG that we had was Githu Muigai, we've never had that. That guy tried, but not much. You see, the office of the Attorney General is a very serious office. For you to be appointed to the office of the AG, you must qualify to be the Chief Justice. you know. So if you bring somebody who is a disqualified magistrate to become the AG, is a serious thing. So we've really never had an AG moment as a country. But the office of the Attorney General is a very serious office. It's a serious office. But of course, even within the Constitution, it's a serious office. But again, let's hope that the incoming is going to be doing good things in that office. Now that is the amicus and the interested parties. Now, what is the rules for amicus? You have to be neutral. You have to avoid political statements. You have to avoid factual submissions. You can only submit on a point of law. For interested parties, they can submit on anything they want, or both points of law and points of fact. Why? Because they are interested in a specific outcome of the matter. So that solves that question. And now I want us to talk about third-party proceedings. Any question before we get to third-party proceedings? Okay, no question. Yes, Alingo.
Yes, Mwalimu, I hope you can hear me. You have said I want to be included as an interested party in court. You have to make an application to court. If I'm not wrong, and I kindly request your indulgence, do you move the court by a notice of motion, or which application is this that you have to file in court?
No, I will not answer that question because it's the common. If I pull out all the recordings that we've had in this class since 2021, the most asked question is which application? Because you want to cram. And are you Christian?
Yes, I am, and I don't want to cram.
Which church do you go to? Why are you hesitating? Kufua Sunday. So tell God to take away the spirit of cramming from you. Guys, an application is an application. Okay? Let me make it easier for you. An application is an application. And this covers all the questions that someone is going to ask in the class about which application is it. An application is an application. Unless the provisions specifies that you do this, or you do a chamber summon or an originating summon, always do a notice of motion. The notice of motion under Order 51 is the default application. If you've seen some of the marking schemes, even the CLE marking schemes, what they normally indicate is that where a student drafts a chamber summon or a notice of motion, they both get the same marks. So don't take your time trying to cram which application is this. No. Just know application is a notice of motion or a chamber summon. Unless the law specifically says chamber summon, always draft a notice of motion. If you're not sure whether the law says notice of a chamber summon or not, draft a notice of motion. I will repeat the two rules. The first rule is two applications are rampant, notice and chamber summon, okay? Unless the law says chamber summons, do a notice of motion. That is the first rule. Number two, if you're not sure what the law is saying, whether it is notice or chamber, do a notice of motion. That covers your end. And remember, drafting a notice of motion is the same. It is the same thing everywhere, anytime, whether you wake up today or tomorrow, is the same one. Okay? So please, don't worry about applications. Ask yourself, what am I going to be putting in our next class, we'll be discussing questions of instituting of pleadings and drafting of applications. And you will see the most important thing is not even which application. It is what do you put in the application? What are the prayers and what are the grounds? But like I've said and I'm saying before, I'm saying again, always draft a notice of motion unless you're very sure it is a chamber summon. I think that covers that. So unless you're sure it is a chamber summon, draft a notice of motion at all times. The structure is the same, the prayers are the same, the rules you're going to come under are the same, the signature and everything else same. Tuko sawa? Alingo.
Yes, mwalimu. Tuko sawa.
Yeah. Yes. So just have at the back of your mind, have a notice of motion. So I want us to talk about third-party proceedings. We have some time with us, so I want us to go quickly through what third-party proceedings are, and I'm going to start back from joinder. So in terms of joinder, okay, in terms of joinder, it is very important for you to understand that joinder is where we bring somebody in and we move somebody out. And we said there are two parties that can join as of right automatically. The first one is a plaintiff. A plaintiff can bring a co-plaintiff. A plaintiff can bring can bring a defendant. Okay, and then the court. Now there's someone called a defendant. Now a defendant cannot bring in a third party. So a defendant cannot bring in a co-defendant, neither can a defendant bring in a plaintiff. We're together. Now, because of that, the only remedy available to the defendant, is to institute a third-party proceeding against the third party that they think that is liable for whatever is happening. If there's an accident, a breach of contract, trespass, whatever, that third party will always be brought by the defendant. Now, that specific application or that specific proceeding is instituted via third-party proceeding. Okay, it is called a third-party proceeding. Now, a third-party proceeding is a proceeding which is initiated by a defendant and leads to issuance of a third-party notice. So I want us to go and talk about how is this application prepared. Now, specifically, this application must be brought under chamber summons all the time. Chamber summon. But again, I've told you, you will not lose any marks if you bring a notice of motion. Okay, what is the difference between chamber summon and notice of motion? Now, the difference used to be historical. Okay, now chamber summons were only brought before the judge in chambers, not in the open court. Okay, notice of motions were brought in open court, but nowadays no judge sits in the chambers. It's almost impracticable. So all applications are prosecuted anywhere the judge wants. So the difference stopped existing. Okay, the difference stopped existing. So just make sure you know how to draft either, just in case. So if you are sure it is a chamber summon like this one, you draft a chamber summon. If you're not sure, just draft a notice of motion. Because now, how do you prepare that application? Before we get there, let us look at some of the reasons why a defendant will bring in a third party. Any question? No question. Okay. Now, the first question is what you're calling contribution. Okay. The first question is what you're calling contribution. Now, contribution is, hey, nimeshikwa, tulikuwa na wewe kuja unisaidie kulipa. Contribution. Number 2, indemnity. Indemnity is nimeshikwa kwa makosa yako, nikilipa lazima unirefund hiyo pesa yangu yote. Okay, so let me give an example. So if you are the plaintiff and you sue a defendant in a motor vehicle accident, this car is insured. Okay, if you successfully sue the defendant might want to bring in someone that is responsible for the accident. Okay, so there are two instances to it. Either the defendant is saying that this third party is the one that caused the accident entirely, is the one that made this accident happen 100%. In that instance, the defendant will be claiming indemnity. That nikilipa 1 million to the plaintiff, refund me my 1 million to the plaintiff. I mean that I paid the plaintiff. Take me back to the place I was before I paid the 1 million. That is indemnity. Number two, if, I want to understand that, if the defendant is saying that we are partly liable, you're liable 50% and I'm liable 50%, then the defendant will be claiming contribution. So contribution means, well, let us side yako, I bring my side and we proceed and pay. That is contribution. That is partly liable. Okay, so those are the reasons why the defendant will want to bring a third party proceeding for purposes of contribution and for purposes of indemnity. So understand that point clearly, guys. Indemnity and the contribution. What is contribution? When both of them are partly liable. And what is indemnity? Indemnity is where the third party is purely liable and therefore the defendant is trying to avoid 100% of the liability. So that is what is going to give us third party proceedings. The next question is, how do you initiate third party proceedings? How do you initiate third party proceedings? I've said it is an application, and this application is brought by chamber summons, okay? And it is specifically under Order 1, Rule 15, Order 1, Rule 15. But I've said if you forget about this, if you forget about Order 1, Rule 15, then you can bring it under Section 1A, 1B, and 3A of the Civil Procedure Rules. Civil Procedure Act. Okay, now what are you asking in the application? You are asking to be given leave to issue, okay, or leave to institute third-party proceedings and to issue a third-party notice to XYZ, the third party. Are you together? And then you pray for cost. Now, I want to project my screen so that we can do it together. Unless you guys are tired. Are you guys tired? Any question in the meanwhile?
We can proceed, Mwalimu.
You sound tired yourself.
I'm good, Mwalimu.
You sound tired. I can hear the way you're breathing. Are you okay?
Very okay, Mwalimu.
Okay, let's proceed. All right, there's someone called Tua. Tua, what is your question?
I've not gotten well the reason as to why they bring out the third party proceedings.
Mm-hmm.
They
What
make
have
the
you?
application. Yeah, I've only gotten that point of one of the reasons is for them to be able to issue a third party notice. So the other one, it may hang.
What is hanging, my friend? Mm-hmm. What did you say is hanging?
I've not understood.
Okay, you've not understood the reasons for third-party proceedings. Hmm?
Yes.
Okay. And what have you understood so far? Tell me, where did you lose me? At what point, so that I know where to get you?
Okay, where you left me is whereby you talked about Order 1, Rule 15, and then you said that where we forget about Order 1, Rule 15, we can indicate Section 1A, 1A, 2A, and 3A of the Civil Procedure Act. So from there, the next point that you made, I did not quite understand well.
Okay, so is it that you've not understood the next point I made, or you've not understood the reasons why someone bring a third-party proceeding?
Yeah, the reasons as to why you bring out that party proceeding.
Okay, but you heard me talk about indemnity and contribution. I've talked about them right now.
Yeah, we are together there.
Okay. All right. So let me try and explain that in this sense. So I've said that if one of the reasons why the defendant will bring a third-party proceeding is for contribution and indemnity. Those are the two reasons. There are only two reasons. So unless you've not understood what is indemnity and what is contribution, I think we're together. Unless you've not understood the reasons are indemnity and contribution. So did you understand indemnity and contribution, or do you want me to go over it again? Mm-hmm.
As for me, I'm good up to that point.
Yes, then what is now your question is?
The reasons as to why we take out the third party proceedings.
And that is why I think okay. The reasons, let me pick you up from where I've left you now. I've said the reasons why you as John, if I sue you, John, right now in court, the reason why you want to bring in Jennifer as a third party is number one, so that Jennifer can help you contribute. So that Jennifer can help you contribute. Contribute to pay me. I'm the plaintiff. I've sued you. I'm suing you for 1 million. It is Jackton versus Thua Joan. Okay? Jackton versus Thua Joan. I'm claiming 1 million from Joan. Now Joan will sit down and say, fine, okay, this 1 million. Hii shida yote si yangu. Jennifer pia alichangia kwa hii shida yenye Jackton ananisu. So, wacha niende kwa Jennifer, nimtafute akuja hapa, anisaidie contribute. So, Jennifer 50, mimi 50, mlipe Jackton 1 million. Okay? That is contribution. Number 2 is indemnity. Indemnity is wewe sasa kusema, hapana, this mistake or this accident was not my fault. It was Jennifer's fault. So Jennifer should come and pay Jackton 100%. So those are the reasons that will drive you to take out a third-party proceeding. Okay? We have said from the very first thing that you as Thua Joan, the defendant, you can't join Jennifer. Or you can't tell me, Jackson, why can't you sue Jennifer? You don't have that right to tell me that. Why? Because I'm the dominus litis. I am the plaintiff. The plaintiff is the master of the suit. The plaintiff will decide who they are suing. So you can't tell me, once I've sued you alone, you can't tell me to bring Jennifer. It is upon you now as Joan to go look for Jennifer in a different suit. Mimi nitakwambia, mimi shida yako na Jennifer mimi sijui, so long as mimi nimelipwa. Endeni mko nje mpigane, mkishaelewana mniletee pesa yangu. Okay? So wewe utapigana na Jennifer through a separate suit called a third party proceedings. Mimi tutapigana na wewe through the normal plaint that I file. Okay? So why are you bringing a third party proceedings against Jennifer? For contribution or for indemnity? Okay? How do you bring it? You bring it through first applying for leave. Okay, you have to make an application to court, asking the court to issue or to grant you leave to issue a third-party proceeding to who? To Jennifer. Once the court agrees with you and say, okay, based on the evidence she's saying, this thing must have happened, then the court will issue a third-party proceeding to Jennifer. What is the court telling Jennifer? Hi, Jennifer, how are you doing today? Now, take notice that Jackton, the plaintiff, has sued John. Okay? John is claiming that you should the court find her liable to pay Jackton the 1 million, John is claiming that you should indemnify her or you should contribute this percentage of the decretal sum for the settlement of the suit by Jackton. Okay? Take notice that if you wish to challenge the position of John or the claims of John, please enter appearance within 14 days of service of this notice. And then lastly, the court will be telling Jennifer, that take notice that if you don't respond within 14 days of the day of this notice, we shall proceed that you have accepted the claims of John, and the court will make orders against you, your presence or your absence notwithstanding. Signed, drawn and filed by, to be served upon. That is all about third party proceedings. Mpaka hapo tumemaliza. Imagine it's as simple as that. So again, to answer your question, Joan, wherever third party proceedings, which is a remedy to the defendant, you as the defendant, you are going to look for Tianga. Why are you looking for Tianga? Because first, hauna pesa ya kunilipa peke yako, na secondly, unasema ni Tianga anafaa alipe. So how do you get Tianga? You cannot just call Tianga on the phone. You cannot just get Tianga on the phone and she agrees to pay. No, you have to force her. How do you force her? You institute a third-party proceeding against her. Okay. Now back to you, John. I am not very sure whether your question has been answered, but I think I have tried to elaborate and use an example so that you understand.
Yeah,
Back to
it
you
is
in
clear
studio.
now. It is
We are
clear now.
together?
Thank you. Yes.
Okay. Is there another question? Okay.
Yes, Doctor, my hand was up.
Haji Barako.
Yeah, so the wording of Order 1 Rule 15 talks about 14 days after close of pleadings. So does it mean that you cannot issue that party notice before close of the pleading? Please clarify.
Yes, you can't. And why can't you? Why can't you? I'm giving the example of Tua, John, and Jennifer. You cannot issue third-party proceedings until the pleadings have closed. Why? Because before the pleadings close, we are not very sure whether the plaintiff will actually go and sue the third party that you want to bring. Okay, you might take out that notice because right now, but the plaintiff was actually planning to join that third party. So you have to wait until the pleadings close. Once the pleadings have closed, remember that nobody can be joined. Even the plaintiff cannot join anyone without leave of court. Now, after the pleadings have closed, then you'll be telling yourself, sawa, huyu jamaa hajaleta huyu, acha niende mlete. So the pleadings must close. Once the pleadings have closed, then you will be sure that this person has not been joined. And because they've not been joined, and I think they're the ones with the problem, let me go bring them through third-party proceedings. Tuko sawa?
Sawa kabisa.
Okay, so I think that is fine. I'm having the application on my screen. So that is the only thing we are going to discuss, and then we're going to close, and then we'll start on institutional pleadings on Saturday. So that we all on the same page. But I want you to understand everything that we've discussed today. Don't go out of this class before understanding anything. Like I've said, please, please, please do me the favor of not leaving the class until you understand. Are together? Okay, so there is my screen with a sample of chamber summon. Let me project. I don't know whether you can see. It's showing it's projecting on my side. I don't know why.
Not yet.
Not yet from my end.
So this is it.
Okay, we can see.
And I'm hoping that you guys are going to pick it very quickly. Okay, so you can see on your screen, we have three things. Okay, we have three things. So we have the caption of the case, that is the Republic of Kenya in the Magistrate Court of Nairobi, the civil suit number that. The parties are the John versus James and Peter. Okay. Are we together? Now, I want you to understand where that is coming from. Now, we have the first respondent, the applicant, and the second respondent. Okay. Now, remember, this one was the plaintiff. Remember, we are using the caption of the case that was already filed. And this one was the defendant. Okay. Let me put that there so that you can understand. I feel like I'm moving too slow. This is not my speed. I'm moving very slow. So let me highlight this one here in yellow. Okay. Now, remember that this is an application that is being made within the suit, within the course. Now, originally, we had John, the plaintiff, okay, suing James, the defendant, okay? John, the plaintiff, suing John the plaintiff suing James, the defendant, okay? Now, James wants to bring Peter, this one here, let me highlight it in green maybe, that you see, wants to bring Peter as a third party, okay? James is bringing Peter as a third party. So for you to bring Peter as a third party, you have to make an application. So the parties in application are not plaintiff defendant. They are respondent and the applicant and the respondent. So James here, who is the defendant, is going to be the applicant. Okay? So James here is the defendant applicant. Okay? Who is the first respondent? John is the first respondent because it's the first in line. Any of them can be the first respondent. So John is the first respondent, and then Peter is the second respondent. Okay, so remember you can't alter it and have James starting first and then John second or Peter first, second. No, it is made in the application, or the application is brought in the course within the suit. Are you together? So that means you don't alter the caption. You just use the caption as it is. So the original caption is as per the yellow, the ones that I've highlighted yellow. Without the application, it was John plaintiff versus James defendant. But James now wants to bring in Peter. And that is why James is going to be the first applicant, John the second respondent, and Peter the second, James applicant, John first respondent, and then Peter the second respondent. Okay. Now, what you need to do is just do a stroke and then write second respondent, do a stroke applicant, and then this one, Peter will just remain the way it is because he's not a defendant. Peter is not a defendant. And then you come, I hope, guys, are we together up to where we are? Do you understand why we have plaintiff, first respondent, the explanation? Do you understand it? Are we together
Yes.
as to
Yeah.
why we have
Yeah.
the, all right, fine. Now let us go to the application itself. So you've made your application, you have your parties there, John being the plaintiff, but also the first respondent, James being the applicant because he's the defendant, and then Peter, who is our proposed third party. We will not have him as a third party here yet because we have not been given the order. Okay, so you're going to have your ex parte chamber summon, right there, and it is made under Order 1, Rule 15 of the CPR. If you forget this specific one, you can say Order 51, you can say Article 159, you can say Section 1A, 1B, and the 3A of the Civil Procedure Act, and all other. So you can mention a lot of provisions there, which covers everything. Are we together? For now, we just go with Order 1, Rule 15. Then, of course, the caption of the chamber summon will never change. Let all parties concerned attend before the Honorable Magistrate in chambers on that day. Let's say it's February of 2025 at 9 o'clock in the forenoon or soon thereafter. So the counsel for the second. Let's have counsel for the defendant, or let's just counsel for the applicant because we only have one applicant. Counsel for the applicant may be hard on the application for orders that. So there's only one order that you're going to be praying for. There are two, but one is the most important order. So the first one, sorry. that the court do grant the applicant leave to institute third party proceedings by issuing a third party notice to who? To the second respondent, who is James, second respondent. You don't have to say nothing else. To the second respondent, full stop. Okay? The other prayer you're going to pray for is just cost of the application. Okay? And then you come back here and tell us which application is based on the following grounds. Okay, ground one, that the respondent, for instance, assuming it is a motor vehicle accident, that the respondent is the registered owner of motor vehicle X, let's say XYZ, the subject of this suit, that this is where now you tell us what you're praying for. Is it indemnity or contribution? That the defendant claims full indemnity from the third party. Should the court find him liable to the plaintiff. So the list goes on and on. Let me just remove this. So these are, I'm just creating these reasons because we don't have a specific fact pattern with us. But in the question that you're going to have, you will see why this person wants to bring in a third party. It could be an accident claim. The third party could be the insurer. This other person could be the owner of the company, could be the person that was in charge, could be a traffic police, it could be anyone. So the pattern, it will, guys, the grounds of your application will always be in the question. It will always be in the question. So just go to the question and get those grounds and copy paste them to your application. And then you'll come back and say which application again is supported. Supported by the supporting affidavit. Supporting affidavit of, let's say our applicant is James, of course. We just have James because we have first name, James. Full stop. That is all. You want to remain as simple. Don't sound sophisticated. Don't want to sound like those applications you see in practice. Be simple, straight to the point. Don't complicate your life. And then you will come here and post you indicate there should be counsel for the or advocates. Advocate for the applicant. And then you come here and say drawn and filed by, oh, sorry. Yes, drawn and filed by. Sorry. You need to have dated at dash. Sorry, at Nairobi, for instance. I said Nairobi. Nairobi. This dash of dash 2024. Drawn and filed by to be served upon, and then you do your supporting affidavit. This is already your application for third-party proceeding. This is already it. So guys, when you draft applications in an exam, you want to be as direct and as simple as possible. In practice, they'll be so verbose. You will add a lot of legalese because because you're paid to write. So you have to write even things that are not relevant. Okay? Your client will pay you according to how many pages you write. So you want to write a lot of things, have 3 pages of just grounds, which is fine in practice. I mean, it is practice anyway. But when you're in KSL, you're doing an exam, 3 hours is not a lot of time. Stick to the bare minimum. Okay? And bare minimum means the minimum allowable, which is the grounds, your prayers, and the grounds and the affidavit. Full stop. Don't complicate things. Just go to the question, make it as simple as possible. So this is exactly what you need. Okay. Exactly. Okay. So your grounds, remember, your grounds will come from the question. At the same time, those same grounds will be forming part of your supporting affidavit. Any question? Okay.
Could be having a question, Madam.
All right, proceed.
Thank you. So I can see the template. Let all parties concerned attend before magistrate in chambers on the 16th day. So is this the defendant's counsel who sets the or where
normally when you draft this application, so you normally leave it blank. Let me just leave it blank unless you're very sure of the date, but you'll not be sure of the date. So you just leave it dash because that will be fixed at the registry. So let a party concerned dash day of dash and that. So what is the question?
Yeah, that's all.
Ah, okay. Sorry. So just leave the date blank because you will not know when the judge might. So in practice, you don't know when the judge will give you the time of the date. So you leave it to the registry so that the registry can decide which date. Yes, Faiza, Cash.
As well, is that precise or is going to be decided at the registry?
The date will be decided at the registry. So once you file it, it is taken to the registry. And then if you file it under certificate of urgency, sometimes you do, sometimes you don't, depending on the urgency. then it will be heard the same day. It will be presented the same day. Okay, so the registry, the clerks at the registry will take it to the judge. Yes, it will be taken to the judge,
I asked
and the
about
judge.
the time. Like you wrote there at 9 o'clock. Is that also that precise, or it's going to be decided at the registry? Because you said the date, but what about the time that is written there?
Now, the time is usually the standard time for a court. Courts normally open at 9 and they run until around 2. And that is why you say 9 o'clock in the forenoon or soon thereafter. So you don't know what time, but courts operate from 9 to 2. Normally, civil courts sometimes can extend on special days, they can extend until 4, but courts rarely sit until 4. So they will start from 9, some will start 8, depending on the judge. Magistrates start at 8, 9, sometimes until, depends, but the standard operating time for courts is 9, from 9 to soon thereafter. So you don't know what specific time, but it's a standard time. It's not other time apart from that, just standard time. Are we together? Okay, so this is the application. So once the court agrees with the application, then remember, then you will need to prepare the notice, the third-party notice. You will need to prepare the third-party notice, which I want you to prepare. So assuming that this is our third-party notice. So in our third-party notice, we are going to have a change here. We are going to have and. Okay, we are going to have and then we are going to change. This person becomes the third party. So just have third party and then plaintiff and then defendant. So plaintiff, defendant, and the third party. The reason why we are saying and is because he is not part of that suit. Okay, so your third party notice will be looking like this, and then you're just going to have here, you're going to have to who? The address of this person here, the address of the person in blue. Is it blue? No, in green. So Peter's address. So to Peter, let's say Macharia. What am I typing? Macharia. PO Box 123 Nairobi. And then you're going to have your third party notice. So I want you to draft that third party notice. I will send you a draft to guide you. So you can see. So the application will have who is the applicant, who is the respondent, and who is the. So both of them are applicant and respondent. And then that person that is in green, that is Peter. Peter will now become the third party. So John versus James, that is the first suit, and Peter the third party. So remember that there are two suits here. There's John versus James, and then there's a third party proceeding between James and Peter. They're all running concurrently, and one doesn't affect the other. Okay? And remember, this one between Peter will only pay James if John is successful. If John is not successful, then the third party proceedings also is going to fail. Okay? Because the third party proceeding depends on the main suit. And then you issue the third party notice, and then the party will enter appearance, and then they'll be hearing, and everything will file their case and all that. And then the court will determine whether the third party is liable. So I will share with you a sample. the group, or a template in the group. So try and come up with a third-party notice in your own words. At the same time, try and come up with an application in your own words, both the application and the supporting affidavit in your own words. You can share with me. I can check it for you free of charge, so that we are all sure that you are doing the right thing. There's no pressure in doing it. You can do it if you want to, or if you don't want to, that's fine. But at your free time, try and close this chapter. So every time, every place, every topic we get to, we'd want to close on the draftings of that topic. So the only drafting that we need in third-party proceedings here so far is the question of third-party proceedings. We will talk about amendments and interpleaders, but later, not now. Okay, so you need to understand third-party proceedings. So we've gone through that, what it is, why it is there, how to get it. Okay, how do you get it? You get it through instituting third-party proceedings. How do you institute that? By issuing a third-party notice. How do you get a third-party notice? By making an application in court through chamber summon, and you ask the court to give you leave. It is leave. You have to get leave to institute third-party proceedings by issuing a third-party notice to the second respondent in that case. And then your ground will always be in the question. You just copy paste them, and then you do your supporting affidavit, which will contain your grounds. Okay, and then you come and issue the third-party notice. Now the notice, like I've said, is a simple statement that, hey, third party, a suit has been filed by the plaintiff to the defendant. The defendant says you are liable to contribute. If you are challenging that, file your response within 14 days. If you don't file a response within 14 days, we shall assume that you've accepted the claim of the defendant. Full stop. Drawn and filed by, to be served upon. Full stop. Guys, si ni rahisi? Drafting a third-party notice si ni rahisi? Okay, so try, and I will send you a template, guys. I will send you a template, but I want you to draft it in your own words. Your own words. Words. If you're coming from Mount Kenya, draft it in Kikuyu. If you're coming from Narok, in Maasai language. Coming from Western Kenya, in Luya land. Okay, if you're coming from the Rift Valley, people from Rift Valley usually get conned. I don't know why. That thing keeps disturbing me, but sour. You guys are so rich that you get conned every time. You don't learn. If you're in this class and you're coming from Eldoret, we need to greet you. We need to send some people our salimie. Guys don't learn. Like, guys, we're in 2024. 2024. People are still being conned like that. 2 weeks apart. Hey, you guys are so rich. Anyway, major shareholders in the government, very, very rich. And the Leni Kulisha conman. Anyway, so what I'm saying is write it in your own language that you can understand. If you can understand English, do so. If you're from the coast, Swahili, so that you understand. Once you put that thing at the back of your mind, there is nothing that can defeat you. So that is how to draft that. So we will discuss that, internalize how to draft applications as well. Remember, drafting an application is as easy as asking your father for money or asking your boyfriend for money. It's a very simple thing. The same way you call your boyfriend and ask your boyfriend, give me money for my hair. That is the same way people draft application. The moment you decide I'm going to text or I'm going to call, that is notice of motion or chamber summon. You decide which one will work better. Okay? What is your prayer? Give me money. That is your prayer. Okay? Give me money. That is your prayer. What are your grounds? My hair is due for whatever. Or I want to go make my nails. I want to go eat. Or it's my birthday. Those are your grounds. Those same grounds, weka kwa affidavit na pelekea advocate for stamp. That is entirely an application. When you call your father to ask for fees, the application is you calling your father. What are your prayers? Give me money. Why do you need money, my daughter? School fees or rent or shopping. Those are the grounds full stop. The same way, in this case, we need a third-party proceeding, okay? So what do you need? Third-party proceeding through a third-party notice, okay? Why do you need it? Give us the grounds. This person is the owner of this vehicle. He was the one who was driving. He knocked me from behind. And because he knocked me from behind, I knocked the plaintiff. Okay? Put the same in the affidavit. Sign. Done with the application, guys. Applications are very easy. Very simple and very easy. Two things only. Number one, the prayers. What are you praying for? Number two, the grounds. Full stop. Don't complicate it. Okay? So try and draft that, and I will see for you. But make sure that before we come back to the next class on Saturday, where we'll be introducing drafting of pleadings and institution of suits, make sure that you are well with topic 5 on questions of joinder, parties, and up to third-party proceedings. As well, you can go to Kenya Law, just do random search, just get a case on third-party proceedings and feed, and you will be fine. Don't worry. At the back of your mind, remember one thing. It is okay not to know how to draft now. It is okay not to know, but allow yourself to learn. Pole pole too. I'm moving very slowly, but we will discuss. If you're doubting, we will discuss everything times 2, and then we'll do also past papers. So don't worry. I've done this a lot of times, so we'll discuss this times 2 and do the past papers that we need to do. There's a lot of time. November is very far. You can do a lot of things until November. So please be kind on yourself. Call your mom, call your dad, call your parents, talk to them, your sisters, be a friend, have fun, eat, sleep well, but also revise. Everything is gonna be fine. I will see you guys. Unless somebody has a question, I will see you guys tomorrow for criminal. Kamunyu Ndungi.
Yes. Yes. Thanks you so much for that session. Just wanted to ask a question about the court in which you are applying to. Is it based on the pecuniary nature or the location, the geolocation?
No, it is based on this is a suit that is brought within a course. Okay. So it's an application that is brought within a course. So the court that it was filed in is the court you bring it in.
Oh, okay, got you.
Yes. So if it was brought in the magistrate court, like you just go to the plaint and copy the caption of the plaint the way it is.
Understood.
Yes.
All right. Thanks.
Okay. All right, guys. So I think yes. Mtu anasema hapo nachomea watu wa Central. Ni watu wa Central